Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. And this is the second and last episode in a very short 2025 WUCIOA series. And the reason I'm calling it out by this series by that title is because this is the beginning of education around WUCIOA. WUCIOA will have a much more expanded impact under Washington law by the time January 1st, 2028 gets here. And between now and then, you're going to have more education about WUCIOA. But for right now, you need to know the information that was in the first video in this series, the first episode in this series, and the information I'm about to give you. So in the first episode, we talked about which communities are WUCIOA communities, and I told you that I was going to tell you about an exception. There is an exception to plat communities. So single-family residential plat communities, if they were formed after July 1st, 2018, they are necessarily WUCIOA communities subject to RCW 6490 unless, and here's the exception, unless they consist of no more than 12 sites, 12 lots, and the annual dues per homeowner are no more than $300. And the developer has no ability to expand the community by adding additional property. All three components are required or there is no exemption. And that is the only exception. So in addition, in this episode, I want to talk about some changes based on the 2025 legislation. The first change is to that small community plat exception. This does not come into effect until January 1st, 2028. But when the law is expanded to cover all plat communities, at the same time, the small community exception will expand from 12 lots to 50 lots, and the annual homeowner dues will expand from $300 to $1,000. We're not going to spend any more time talking about that right now. More education will follow between now and January 1st, 2028. But I did want to give you that ray of hope that there is a slightly expanded small community exception when all plat communities become subject to WUCIOA. The other really important change under Washington law that I want to make sure you understand right now is that for properties that are subject to WUCIOA, they are WUCIOA communities, CIC communities, subject to RCW 64.90, and a resale certificate is required, and a resale certificate is required for any property that falls under the purview of RCW 6490, any WUCIOA community. A resale certificate is required when the seller sells the property, unless the buyer waives the right to receive that resale certificate. And you might ask, why would a buyer ever waive the right to receive the resale certificate? It might not surprise you if you think about it long enough to know that I get this question often. Can a buyer waive the right to receive the resale certificate? And the reason buyers might want to waive the right to receive the resale certificate is because a seller is less flexible in their negotiations if a buyer has an ongoing right to rescind the transaction. Will a seller agree to move out and give me possession on the day of closing? Seller says, nope, not if you can rescind the transaction all the way up until the day of closing. I have to have some assurance that you're not going to rescind the transaction before I move out. And if I'm obligated to deliver you a resale certificate and my failure to do so gives you the right to rescind the transaction, then I can't move out and give you occupancy on the day of closing because I can never shake your unilateral right, buyer, to rescind our transaction. And so you might say to yourself, well, then solve the problem, seller, and deliver the resale certificate. And herein lies the problem. What if the seller is selling property that's subject to an association and the association won't generate the resale certificate, won't or can't generate the resale certificate? Because a seller cannot create the resale certificate. A resale certificate, it is a disclosure form, but it's disclosing the health of the association. It's not the seller's disclosure regarding the condition of the property. That's Form 17, and sellers generate that form themselves. Sellers cannot generate a resale certificate. The association has to do that. And so if the association is unwilling or unable to do that, and seller has an obligation to deliver that resale certificate, saving buyer the right to rescind until that resale certificate is delivered and then for another 5 days thereafter, then you can see the conundrum. A seller who can't get a resale certificate can never shake the fact that the buyer could rescind the transaction all the way up until closing. And so the legislature created a waiver process for that buyer to be able to inspire, if you will, a seller to have a little bit more flexibility in the negotiations. And so there are now statutory criteria, and I have to read them because they're fairly complex and I don't want to get it wrong. The seller has to attest to the fact that the resale certificate is unavailable. And the resale certificate can be proven unavailable by one of four means. The seller will attest that the homeowner association has failed to provide the resale certificate within 10 days following request and seller's delivery of payment to the homeowners association. There is a statutory cap on what that payment can be, but the association will set their own payment criteria. Number two, the seller's Form 17 could disclose that there is no homeowners association and no regular periodic assessments against owners of the property, against the seller of the property. Number three, the seller may attest that they have owned the property for at least a year, at least 365 days, and that during that time there has been no notice of an annual meeting from the homeowners association, no notice of budget ratification, assessments, or CC&R enforcement in however long the seller has owned the property or the last 5 years if they've owned it for more than 5 years. So if a seller has owned it for at least 1 year, then they can make this attestation for the time period they've owned the property. And if they've owned it for more than 5 years, then they would have to be able to make this attestation regarding the last 5 years. And here's the final option. The seller attests that the seller has made 3 good faith attempts to request the resale certificate and to remit payment, and the seller has received no response within 3 business days from anyone in the association who could generate that resale certificate. If any of these criteria are applicable, then the seller can attest that the resale certificate is unavailable. And if based on the seller's attestation that the certificate is unavailable, then the buyer can waive the right to receive the resale certificate. And if the buyer waives the right to receive the resale certificate, then that would remove the buyer's ability to rescind the transaction. If you have questions on this topic or any other, please ask me a question by visiting warealtor.org and following the links to the legal hotline. Thank you for being a Washington Realtors member.